UGC NET Law examination, and this time we are conducting our live mock on fundamental rights, part 3 of Indian Constitution. So I hope we all are excited for this. So today, those who are our new attendees, let me just tell you the format of this particular quiz. So we'll be having certain amount of questions where those questions will be based on MCQ format, and you have to answer the same. In the end of each question, we'll tell you the correct answer along with the explanation and how you need to approach that particular question. So I hope this will be a very exciting exercise for all of you, and I will definitely appreciate if each one of you will participate in this particular quiz. Also, this is a free live mock session, so avail this opportunity at large. At the end of the session, we'll declare our top 3 winners for this session. So get ready, participants. All right. As a quiz organizer, we have with us Arpana Sachdeva. She is an academician and associate at Law Seco. So I welcome you, ma'am. And before we start our session, I'll request you to tell our participants how many questions we'll be having today and the time allotment for the same. One small rule for the quiz, that when you will be answering for those particular questions, you have to mention the question number. This is for everyone. Please kindly follow this rule, because this helps me to keep a track of answers of your questions. So first you need to write a particular question number, right, and then you have to write your correct option, and then and also two options for the same question will not be applicable. So let's start with a quiz, and Arpana ma'am, over to you.
Yeah, thank you, Anu, for the warm welcome. And in this particular webinar, we will going to have 20 questions from fundamental rights. Most of them are based from the past year questions of UGC NET. And the time allotted for each question will be 1 minute, that is 60 seconds. And for the questions which are based on match the following, 15 seconds will be given extra to all the participants. So best of luck. So we will start our quiz. I'll just share my screen.
Right.
So my screen is visible to everybody. Is it
Yes.
visible, Anu?
Yes.
Yeah. So this is the live quiz on fundamental rights based on UGC NET JRF past year question papers and similar questions which may come in the question paper. Now, the first question is, in which of the following case the Supreme Court held that the Audi Ultram Partem rule is essence to enforce the equality clause in Article 14, and it is applicable not only to quasi-judicial body but also to the administrative order adversely affecting the party in question? The options we have are UP Warehouse Corporation versus Vijayanagara, Delhi Transportation Corporation versus DTC, AK Gopalan versus State of Madras, and Gulupai Nageshwar Rao versus APSRTC.
And your time starts now. Please mention your question number, then write your correct option. And we have one participant, Subhash Chander Pooja. Please write your question in a chat box. Answers in chat box. Uh, 15 more seconds to go, participants. Try to answer. And time's up.
Okay, so the correct option is option B. That is Delhi Transportation Corporation versus DTC Mazdoor Union.
Right.
So, yeah. So let us go to the next question. The next question is, in which of the following case the Supreme Court said that fundamental rights and directive principles aim at the same goal of bringing about a social revolution and enforcement of welfare state, and they can be interpreted and applied together, and they are supplementary and complementary to each other? Menka Gandhi, Re-Kerala Education Bill, Minerva Mill, or Keshwanand Bharti?
Your time starts now. 15 more seconds to go. And time's up.
Yes. Manu? The correct option is D. That is Keshwan and Bharati. In Keshwan and Bharati, the Supreme Court said that fundamental rights and directive principles have the same goal, and they are supplementary and complementary to each other.
Right.
Right. Now, the next question is, the Constitution of India incorporates the rule of law in Article 14, Article 19, Article 21, or Article 32?
Time starts now. I guess it was a direct question, so many participants have already answered to this question. But still, we have 10 more seconds, participants, and time's up.
Yeah. So the correct option is option A, that is Article 14, as Article 14 talk about equality before law. So the rule of law is incorporated under Article 14. Now, the next question, which of the following is not included in the definition of law under Article 13 of the Constitution of India? Legislation, customs, usage have no force of law, or ordinance?
The time starts. Whosoever is answering over YouTube, kindly mention your question number. Then only write your answers. We have 10 more seconds to go. And time's up.
Yeah, thank you, Anu. So the correct option is option C, that is usage having no force of law. As Article 13 talks about all laws in force in the territory of India immediately before the corporation of constitution, and this any law which has state has made, or any ordinance that, or any legislative bodies, or the customs which is being going on in the uh, country, like Hindu law or Muslim law, all the personal laws also. So the what Article 13 do not include is usage having no force of law,
Right.
right?
Yes.
Chaliye. Now the next question: which of the following article of constitution uses the term material law, sorry, martial law? Article 33, Article 34, Article 352, Article 353.
The time starts. Okay, 15 more seconds to go, participants. And time's up.
So the correct option for this question is option B, that is Article 34. So Article 34 talks about restriction on rights conferred by this part while martial law is in force in any area. So Article 34 uses this term martial law,
Right.
right? Shall
Yes.
we move further, Anu?
Yes, please.
So question number 6 talks is answer the following by using code given below. Economic justice is one of the objective of Constitution of India. It has been provided in preamble, fundamental rights, directive principle of state policy, and fundamental duties. So you have the options that 1 and 2 are correct, 1 and 3 are correct, 2 and 3 are correct, or 2, 3, 4 are correct.
The time is already started, participants. Ten more seconds to go. And time's up.
Yeah, thank you,
Please
Anu.
stop answering.
So the correct option for this question is option B. That is, sorry, that is number 1, preamble, and number 3, that is directive principle of state policy. So in
Right.
this, we have this term of economic justice.
Correct. Okay.
So the next question we have over here is the match the following. List 1 have the articles which are been amended, and list 2 have the amendments by which these articles are been amended. So list 1 have article 16 subclause 3, article 19 subclause 5, Article 19 subclause 6, and Article 31A subclause 2, clause A. And list 2 have Amendment 1, 17th Amendment, 7th Amendment, 44th Amendment. And on the right hand side, we have the code, and you have to match the uh, these list 1 and list 2 using these codes available with you on the right hand side of your screen.
Okay, participants, your time has already started, and for this question, 15 more seconds will be given to you. 1 minute up, 15 more seconds to go. And time's up.
Yeah, thank you, Anu. So the correct option is option A. So option A talks is the correct, where Article 16 subclause 3 has been amended by 7th Amendment. Article 19 subclause 5 is being amended by 44th Amendment. Article 19 subclause 6 is being amended by First Amendment, and Article 31A subclause 2 clause A is being amended by 17th Amendment. So while preparing for UGC NET, it is very important that we should know when the constitution has been amended and what provisions are being amended by which of the amendment. So this is a very important part of UGC NET preparation when we talk about constitution.
Yes.
Now, this question is also matched the following. The rule is same. By using code, you have to answer this. List 1 talks about the article, and list 2 talk about the provision which it have. So Article 13, Article 15, Article 20, Article 23. List 2 says about protection in respect of conviction of offense, protection of traffic in human being and force law, prohibition of traffic, prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth, and law inconsistent with or in derogation of fundamental right.
Your time starts now, participants. For this question, 15 more seconds will be given. 1 minute up, 15 more seconds to go. And time's up.
Yeah. So the correct option is option D, that is Article 13 talks about laws inconsistent with or in derogation of fundamental rights. Article 15 is a prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth. Article 20 provides protection and respect of conviction for offences, and Article 23 provides prohibition of traffic in human being and forced labor.
Right.
Right?
Yes.
So let us move further with question number 9. Question number 9 talks about which of the following statements are correct. Use the code and answer. Freedom of press include right to print and publish news, distribution of printed matter, criticism of public affairs, and censorship. And the code we have 1, 2, 3, 4 are correct, 1, 2, 3 are correct, 1, 3, and 4 are correct, and 2, 3, and 4 are correct.
Participants, your time has already been started. We are on question 9. So kindly mention your question number. And we have 5 more seconds to go. And time's up.
Okay. So the correct option is option B. That is, in the context of freedom of press, it includes right to print and publish news, this distribution of printed matter, and 3, that is criticism of public affairs.
Right.
Now, the next question here we have is, if I was asked to name any particular article in this constitution as the most important and article without which this constitution would be nullity, I would not refer to any other article except one, Article 32 dash. This is the soul of the constitution and the very heart of it. Was observation of Justice P.N. Bhagwati, Dr. B.R. Ambedkar, Justice V.R. Krishna Iyer, and Pandit Jawaharlal Nehru.
Your time has already started, participants. Fifteen more seconds to go. And time's up.
So the correct option is option B, that is Dr. B.R. Ambedkar, giving importance to Article 32, said that without Article 32, Constitution will be a nullity. It do not have the Article 32 is the soul of the Constitution because it provides us with the rights, and without Article 32, nobody can go to the Supreme Court and ask for their enforcement of rights. If somebody's rights are been violated, that person has nothing to do if Article 32 was not there. So Article 32 is the soul of the Constitution, and that was given by Dr. B.R. Ambedkar.
Yes.
Now the next question is, which of the following statements is or are correct? Chapter 3rd of the Fundamental Rights Chapter 3rd on Fundamental Rights of Constitution is based on Bill of Rights of USA. Right to die is a fundamental right under Article 21 of the Constitution. Indian Constitution is a complete federal constitution. fundamental right can be waived under the Indian Constitution? The options we have here is only two, 3 and 4 only, 2 and 3 only, 2, 3 and 4. So here we have to mention that which is incorrect.
Yes. Am I audible? To
Yes,
Okay.
you are audible.
We have 15 more seconds to go.
I guess time is up, Anu. Anu, I guess we lost the connection with Anu. So the correct option for this question is option D. That is only option 1 is correct. That says that chapter 3 of fundamental right on the constitution is based on the bill of right of United States of America. Now let us go to the next question, which is again a match the following question. This list 1 and list 2. List 1 talks about what the judgment has to say, and list 2 talks about the judgment. So list 1 is says about equal work for equal pay. Agencies or instrumentalities of the states are connected under the definition of covered under the definition of state under article 12. Fundamental rights and directive principle are supplementary and complementary to each other, and damages can be awarded for violation of fundamental rights under article 21 of the constitution. Here we have list 2, which says R.D. Shetty versus the International Airport Authority, Rudra Shah versus State of Bihar, Randhir Singh versus Union of India, and Uni Krishnan versus State of Andhra Pradesh. And you have to answer accordingly using the code. So for this question, we have extra 15 minutes.
Yes, and your time started. 1 minute up. We have 15 more seconds to go. And time's up.
Yeah. Thank you, Anu. So the correct option is option A. That is, sorry. Option A, that says that uh, Randeep Singh versus Union of India, it was said equal work for equal pay. Then in R.D. Shetty versus International Airport Authority, it said that agencies and instrumentalities of state are covered under the definition of state under Article 12 of the Constitution. And in Unikrishnan versus State of Andhra Pradesh, it was said that fundamental rights and directive principle are supplementary and complementary to each other. And lastly, in Rudul Shah, it was said that damages can be awarded for violation of fundamental rights under Article 21 of the Constitution. Now, the next question we have again a match the following. List 1 has the article and what article has been provided, and list 2 talks about the amendments. As I already mentioned, amendments are very important while we prepare for UGC NET in the Constitution.
What was the correct answer for 12? Option
B.
Right. Okay.
Sorry, no, option A. Option A was the correct option for question number 12.
Right. Okay.
Okay? Yeah. Now, list 1 talks about Article 15, subclause 4, providing the special provisions for socially and backward classes. Then Article 13, subclause 4, providing for nothing shall apply to any constitutional amendment. Article 16, 4A, providing for consequential censurity for promotion to, and Article 21A, providing right to education as fundamental rights. Now these provisions were added in 25th Amendment, 85th Amendment, 86th Amendment, or the First Amendment. By using the code, you have to answer this question.
And your time has already started. Question number 13. Fifteen more seconds to go for 1 minute. Extra 15 seconds are more. Ujjwala, we are on question number 13. And time's up.
Yeah. So the correct option is option B. That is, First Amendment provides Article 15, subclause 4. Then 25th Amendment has provided Article 13, subclause 4. And 85th Amendment has provided Article 16, subclause 4A. And lastly, 86th Amendment, we got right to education as fundamental right under Article 21A. Okay. So now we come to the next question, which says, which of the following statement or statements is or are correct? So here we have to mark correct statements. Fundamental rights are not absolute, they are subject to reasonable restriction. Freedom of press is implicit in Article 19 of the Constitution. Socially and economically backward classes of person are entitled to get benefit under Clause 4 of Article 15 of the Constitution. Equal protection of law under Article 14 of the Constitution is based on English law. And the code we have over here is 1 and 2 are correct, 1, 2, 3 are correct, 3 and 4 are correct, and all 4 statements are correct.
Your time has already started. Fifteen more seconds to go. And time's up.
Yeah. Thank you, Anu. So the correct option for this question is option A. That is only 1 and 2 are correct. That is, fundamental rights is not absolute. They are subject to reasonable restriction. And freedom of press is implicit in Article 19 of the Constitution.
Right.
Now, let us come to the next question. That is, in which of the following cases the Supreme Court has held that the word law in Article 21 does not mean merely an enacted piece of law, but must be just, fair, and reasonable law? A.K. Gopalan versus State of Madras, Menaka Gandhi versus Union of India, both A and B, and none of the above.
Time started. We have a few more questions left in our pocket today. Fifteen more seconds to go, participants. And time's up.
Thank you, Anu. So the correct option is option B, that is Menaka Gandhi versus Union of India, where Supreme Court said that the word law under Article 21 just does not mean that it should be just a mere law, but the law should be just, fair, and reasonable law. If that law is not just, fair, and reasonable, then that is violating the Article 21 of the Constitution.
Right.
Right. Now let us come to question number 16. In which of the following statement is true? All incriminatory statement are violative of Article 20 subclause 3. All self-incriminatory statement punished under compulsion are violation of Article 20 subclause 3. All self-incriminatory statement furnished under compulsion are violation of Article 20 subclause 3, or none of the above.
Your time starts, participants. We have 15 more seconds to go. Try to answer. And time's up.
Yeah, thank you, Anu. So the correct option over here is option C, that is self-incriminatory statement furnished under compulsion are violative of Article 20 subclause 3 is the correct statement.
Right.
Now, let us come to next question, which is without paying the remuneration, labor taken from the prisoners is forced labor and violation of Article 20, Article 21, Article 22, and or Article 23. So it is talking about forced labor.
Yes. And your time is already running, participants. Fifteen more seconds to go. And time's up.
Yeah. Thank you, Anu. The correct option is option D, that is Article 23, as Article 23 talks about prohibition of traffic in human beings and forced labor.
Right.
Right?
Yes.
So now let us come to next question, that is in which of the following amendment the word nothing in Article 13 shall apply to any amendment made under Article 368 was inserted? 22nd Amendment, 24th Amendment, 42nd Amendment, or 44th Amendment?
Your time has already started, participants. Uh, 10 more seconds to go. And time's up.
Yeah. So the correct option for this is option B, that is 24th Amendment, which came in 1971, which has inserted subclause 4 of Article 13, which says nothing in this article shall apply to any amendment of this constitution made under Article 368. So this statement is the subclause 4 of Article 13, which was added in 24th Amendment. Now we have next question. In E.P. Royappa case, which of the Supreme Court judge pronounced the new concept of equality as equality is dynamic concept with many aspects and dimensions, and it cannot be crippled, combined, and confirmed within traditional and
Doctrinal
doctrine
limits.
limits.
Right. So participants, your time has already started. 15 more seconds to go. And time's up.
Yeah, thank you. No? So the correct option is option B. That is Justice P. N. Bhagwati stated this statement in the case E.P. Royappa case, where he gave the new concept of equality.
Okay.
Yeah. So this is the last question for the session. That is Article 20 and Article 21 has been taken from the purview of Article 359 of the Constitution of India by 42nd Amendment, 43rd Amendment, 44th Amendment, or 59th Amendment.
Your time started, participants. This is the last question. Try to attempt it. We still have 10 more seconds. If anybody would like to answer. And time's up.
Yes. So the correct option here is option C, that is 44th Amendment. So in Article 359, when we see provision subclause 1A, so here it is written that Article 20 and 21 has been removed from the purview of Article 359. So this was the last question. Thank you so much for your cooperation. And I guess now Anu will provide us with the winners.
Right. Yes, ma'am. Thank you. So I'll get back till the time you just take over the webinar, and I'll get back with our today's winners, right?
Yeah. Okay. So this was a webinar on live quiz on fundamental rights. As it has been seen in UGC NET that most of the questions from constitutions are being asked from fundamental right, but at least two questions from each year I have seen that there are at least two, or some in some years there are only one, but there are questions from fundamental rights. This portion has never been left behind, and as you can see from this particular topic only we can find so many questions, and these all questions were based on the past year question papers of UGC NET. So when we see the what type of questions are being asked in fundamental rights, so the area is very vast. So here we are finding questions on case law basis also, like in which case law the statement has been given. We have also seen that in these questions most of the judges who has given the most important uh, interpretation of fundamental rights, those questions are also being asked based on the name of the judges also. So this is the second, and then we have seen amendments in the constitution, basically majorly focusing on the amendment parts of fundamental rights is being asked over here. And thirdly, these statements that are not directly asked from the bare act of the constitution as in fundamental right, but for confusing us they have given different statements from same article, and they have asked us which statement is the correct form from that. So we have to be thorough with the theory of the bare act also, plus the important case laws of the constitution, based on fundamental rights. And importantly, the latest judgments on fundamental rights are very important. As in 2020 paper, we have seen that 2019 landmark judgments are also there. The recent judgments are also being covered in UGC NET based on fundamental rights. So this is the most important concept of if we need to score at least major portion of the constitution, we cannot leave behind fundamental rights. That's why I've taken this webinar based on only fundamental rights and not the constitution as a whole. And for our constitution as a whole, we will take other provisions in a separate webinar.
Right. So thank you for sharing your insights with us, Arpana. So today, we are excited for the winners, and I'll first of all say thank you to each one of you who participated today, both to our Zoom webinar participants and the YouTubes, because we were live today. So thank you, YouTube participants, for participating, and for the Zoom participants. So now I'm going to take a minute to announce our today's winners. So I've taken three positions. I've taken three people name जिन्होंने today they have secured good positions. So at third position we have today two winners. We have Sukanya and Jagannath. They have scored similarly. So congratulations, Sukanya and Jagannath. On second position we have Pushpinder Kaur. So congratulations, Pushpinder. On first position, we have Vartika Mittal. So, very congratulations to Vartika, Pushpinder, Sukanya, and Jagannath. So, this is all. And if anybody is having any question, they can ask in a chat box, or from YouTube session. If anybody has any question, you can ask your queries. Arpana, could you please tell us what is the correct answer? What was the correct answer for question number 15? Naveen Prakash is asking.
Question number 15. Yeah, sure. 1 minute.
Okay, our YouTube winners, if you have any questions for today's session, you can ask.
So the question number 15 was 1 minute. Was in which of the following cases the Supreme Court has held the word law in Article 21 does not mean merely an enacted piece of law, but must be just, fair, and reasonable. So the correct option for this question was B, that is Menaka Gandhi versus Union of India.
Right. Okay. Thank you, Arpana. Another question we are getting from Vartika for question number 16. She is asking basically the difference of between the options B and C.
Yes. So the option B talks about all self-incriminatory statement furnishing under compulsion are violative of Article 20 subclause 3, and it said all, and it says the self-incriminatory statement furnished. See the word, in B we have the word all, and in C we do not have this word all. So if we read Article 21, I just opened from my book, Article 20 subclause 3. So here you will find word all is not being included. So this is the major difference in between 1 and 2. So let us see Article 20 subclause 3. So in Article subclause 3, it says that no person accused of any offense shall be compelled to be a witness against himself. So see, if we see when if we connect this with CRPC, then if only the statements of statement with before the police is not admissible, but for any other extra body which is specialized bodies, these self-incriminatory statements are admissible. For example, CBI and other special bodies which are formed. So all self-incriminatory statement are not correct. Only self-incriminatory statement is correct.
I hope Vartika has got her answer. Uh, okay, from YouTube, we have one participant, Pulkit Daswal. Okay, so actually, we have given our top three winners from all over, from the participants who participated from YouTube as well as on the Zoom. Yes, actually, there were certain rules and regulations, like you have to mark question number along with your answer. So there are certain things which you need to follow up. So I have taken a consolidation of both YouTube and Zoom webinars attendees winners. It is a sum of all of you, right? So we have one more question from Roshan. He's asking how to crack the question from judgment and how to prepare for that.
Yes, this is a
That
very
right. Before that, I'll ask my participants to rate this particular webinar from on the scale of 1 to 10, 1 being the lowest and 10 being the highest. Yes, ma'am.
yes. So this is a very important question because this is the only part where most of the people lack. And if you crack this question, then DRF is on your way. But so how to crack this is that see the past year question papers first. See how many what kind of questions where these statement type questions are coming. So when we analyze these things, we can see that only landmark judgments only they are only covered in this statement kind of thing. As a non landmark judgments, I mean, even not the landmark judgment, the very important judgment is like Menaka Gandhi, Keshwan Bharti ho gaya. So in sub mein se you will find these type of questions. So make a list for it. Make a list that what were the questions were being asked there, which were statements, and what are the judges' name. So just you have to make a list, name of the judges, case, and the statement. So if you make a list and you have a list with you, you can always revise it. Have a list, because I can show you this, that I also make these kind of list and prepare accordingly. Because without making a list and without marking it, uh, small terms there, uh, numbering it, that will help you. And plus also mention the case year also, because many a times we have seen chronological order se bhi questions aa jate hain, that they have asked chronology. Also mention the case year, name, judge's name, and the statement. So you have to make 4 columns for it and make a list. So because without making a list, that cannot be done.
Right. Correct. So I guess we have taken all the relevant questions and we have received a good feedback from our participants, and definitely we'll come up with another session on some other live mock. As Arpana already said that we'll try to conduct another webinar on the constitution, like we'll take whole provisions of the constitution in that webinar. So till the time, stay safe at home. And now I'll sign off. And thank you, participants, for joining. And thank you, Arpana, for conducting such a wonderful quiz. And Vartika and other participants are saying that the questions quality was also good. So yeah, of course,
Yeah.
we try to come up with certain good content. So keep participating, keep quizzing. And now I'll sign off. Yeah. Thank you, Arpana, for joining.
Thank you, Anu, and congratulations to the winners.
Congratulations. Yes. Now I'll sign off. Thank you, everyone.